In this lecture, we would like to discuss another most important legal and political concept, that is political obligation. So, in regards to that, we will discuss the very introduction relating to political obligation. Membership of the state is compulsory and no individual today can escape this compulsion, but is he under obligation to endorse every action of his state? Is the individual justified in resisting the law which falls far short of his value judgment? This, in brief, is the problem of political obligation. Legally viewed, a citizen is obliged to obey every express will of the state. The state is the repository of sovereign power and the exclusive source from which law emanates. As Professor Laski in his An Introduction to Politics observes, the commands of the state must justify themselves on grounds other than their source. So, also we have found different grounds of political obligation, as in the theory of divine right, so also in the theory of social contract, and also among the idealists and also among the Marxists. So, the theory of divine right, which found its rational development in the thinkings of Sir Thomas Aquinas, seeks to treat human law as an emanation from divine reason, as an aspect of cosmic fact. The theory insists as a logical consequence on man's obedience to law, which is the expression of divine authority. And the theory of social contract, on the other hand, binds the citizen to the governing authority by the reasoning that man himself, along with others, have created the authority through contract. Man has consented to the power of the state to issue commands, hence he is under obligation to obey its laws. Both the theory of divine right and theory of social contract act on historical and abstract doctrines based on non-verifiable assumption. Hence, with the emergence of empirical thinking in politics, these theories have largely been abandoned. The idealists like Hegel, who recognize the state as the embodiment of reason and reality of freedom, find the concept of freedom meaningful only in the context of state sustained laws. They equate law with freedom, thereby implying that the enlargement of the orbit of law involves the expansion of the frontier of freedom. Hence, in the Hegelian state, an individual is under necessary obligation to obey the law. Such an absolute conception of the state automatically rules out the popular right to resistance. But the realist theory of state, as Laski observes, the idealistic theory remains a formulation of a conceptual state rather than of the state as we know. The problem of political obligation depends not on a priori consideration but on empirical tests. And as regarding the Marxists, with their beliefs in economic determinism, treats the question of political obligation in a particular perspective. The nature of political obligation is not the same in the capitalist system as that in the socialist system. In the former, an individual has the right to resist, but when the capitalist system turns into a socialist, either the same individual is denied the right to resist. However, may the legal code of the state deflects from its scheme of values. So all the theories discuss that we found the very problems of political obligation is in the light of some assumptions which are arbitrarily chosen and not empirically verified. So, the very relation is the very fundamental question of political obligation is based on how individual confronts the laws of the state of which he is a member. An individual is legally viewed obliged to obey the law made by a legally constituted authority in conformity with fundamental law of the land. The law is valid, hence is binding upon the citizen, but that law is, in order to possess value, must satisfy the state of what Professor Ernest Barker expressed that the test of justice, or what Professor Laski says, it is unmoral adequacy. So, this is how Professor Barker rests the very relationship between individual and law on the regards to political obligation, on the concept of test of justice. And Professor Laski rests on the concept of moral adequacy. So, the distinction between value and validity must be borne in mind in any examination of the question of political obligation. If a valid law fails to represent justice, an individual, as Barker admits, has the right to resistance, and his super political obligation should get the upper hand on political obligation. But when he defies the law, he disturbs the general scheme of law and order and the general validity of obligation. So, the very assessment of worker is as old as the calculation of Sir Jeremy Bentham and does not transcend the limits of traditional hesitancy. And as Professor Laski, whose analysis of political obligation is free from traditional prejudices, concedes the individual the right to resistance and the right to rebel. So, against the command of the state which denies the individual the prospects of self development. The very problem of political obligation should be dealt with not in isolation but in relation to a particular political system. Basically, the problem is inseparably connected with democracy. So, we would like to discuss the very relation of democracy, political obligation, and rebellion as it was founded in the theories of Professor Thomas Green and also why Edmund Burke, the English conservative philosopher. So, realistically viewed, a state is an administrative machinery and not a metaphysical, abstract entity. Law of the state has no a priori sanctity. So, when law departs from individual scheme of values or from his experience, he has the right to resistance. As Professor Thomas Green insisted that rebellion therefore is a contingent duty on the part of the citizen, but the individual must try all other methods before he pursues the path of rebellion, and he should rebel only on major issues of great social significance. Democracy is a government wide discussion. Continuous resistance will make the functioning of government wide discussion impossible. The right to resistance thus must be exercised with caution and only as a last resort. As Professor Edmund Burke insisted, the right to resist is the medicine of the Constitution and not its daily bread. So, we have completed our discussion on political obligation, which is as an important place both in legal science, also in political science, and it is a relevant proposal in every political system and legal system. As regarding the very question of political obligation, so in our next upcoming lecture, we would like to discuss public opinion.